We're on the record in People versus file number 256807. Excuse me, the record should reflect that Mr. Hackney is present here in the courtroom today. This is the date and time set for sentencing. Mr. Hackney, did you have a chance to go through the pre-sentence report and talk to Mr. Brown about that?
Yes, Your Honor.
Okay. And Mr. Brown, are there any additions, deletions, or corrections to that report?
There are, Your Honor. The first one is where it mentions his credit for his time served. I think this was based upon an original sentencing date of April 9th. Obviously, we had the ice storm. He has been incarcerated up until now and still is. However, he was sentenced on that case that he's dealing with from Roscommon on April 29th. I was talking to Mr. Rolla and Ms. Davis. I believe that his correct credit should be 22 days.
22 days.
22?
That's
20, and then the 2 that's already.
right. 20 additional days to the 2 days you already credit.
Okay. Any other corrections?
No, Your Honor.
Are there any challenges to the scoring the guidelines?
Yes, there are, Your Honor. While I find myself in a rare position to do this, I believe that PRV 6, while currently scored at 5, should actually be 10.
That's because he was on a delay of sentence for felony detention.
Okay. Do you agree with that?
For that reason, exactly. Yes. Thank you.
Okay. So PRV 5
Should be 10. It does not change the range.
Okay, so that gives us a total PRV score of 22 then, but the level remains C.
Correct, Your Honor. So I think it's up to 24.
No, Your Honor. Total PRV is 17.
17. Right.
Right.
Still doesn't change the score.
Okay, thank you. Any other challenges, Mr. Brown?
No, Your Honor.
Rolla, do the people have any additions, deletions, or corrections?
Other than those already on the record, no, I do not.
Any challenges to the score?
No, Your Honor.
I did receive a written victim impact statement. I did have a chance to review that prior to the hearing today. Did you have any victims that wish to address the board?
That would be Mr. and Mrs. Vaughn, and no, it's fine. Understanding they're not going to be here. That's why they provided the written statement. We asked the court to take that into consideration in sentencing, and of course, have it attached to the PSI.
Thank you. Anything on behalf of the people for allocation?
Just briefly, Judge, it's the first felony, however, that might be in its face a little bit also deceiving because the defendant, with an offense date of prior matter of August 8th, 2024, was on a delay of sentence. That's item number 1 of 3 in his adult criminal history. So although it is technically the first felony, he has the other matter that he's not been sentenced on. There's a recommendation of probation, 3 years jail time, and 2 days credit. I think that's appropriate as long as it includes the restitution of $4,150 to the Mr. and Mrs. Vaughn. Thank you.
Mr. Rolla, do you know, or Ms. Davis, what the current status of his Roscommon delay is?
Wasn't that we just got resentenced on, Larry? I thought it was.
It looks like in the narrative on his criminal history, they actually extended the delay until, oh no, that was November. Delay of sentence until July of this year.
Was that the result of this case or?
Roscommon.
Did they take that action because of the conviction here or we don't?
I don't know.
No, Your Honor, that was because of payments. So they extended so I can make my payments.
So they haven't revoked your delay or anything because of this case?
No, Your Honor.
Okay. All right.
They dismissed this as a violation in Roscommon.
Okay. Mr. Brown, anything on behalf of Mr. Hackney today?
Yes, Your Honor. I did have an opportunity to speak with him. He has currently got a fiance. He has 3 children. The interesting thing, and I always find these kinds of cases interesting, is that he is 35 years old. He has no juvenile record, no adult record up until just a couple of years ago. And it looks like he just went on a theft spree here. So I don't know what was going on. I do remember that I believe when he took a plea to this, he may have paid his rent with some of this money, probably going through some severe financial difficulties. Obviously not any kind of a reason to take somebody else's money and use it for your own purposes, and he does know that is wrong. But I think maybe with some proper counseling or something, he's definitely not a lost cause here. The lack of history is what astounds me, given his age. Usually when we see things like this, they have a history kind of building up to it. And he just seemed to, within a year or two, start doing these things. So I would ask the court to take those things into consideration when imposing a sentence. I would also, I know the recommendation is for 30 days. However, the probation will be for 3 years. That's going to keep a very strong eye on him. There's going to be a lot of jail that can be held over his head. I don't disagree with that. That will keep him on the straight and narrow as well. But it is my understanding he's going to be released from Roscommon tomorrow. So if he gets sentenced here, put in jail here, goes back to Roscommon, gets released tomorrow, gets brought back here, put in jail here for another few days if they follow the recommendation. So I would ask the court to give him time served, no objection to the restitution.
All right, thank you. Mr. Hackney.
No, Your Honor, he covered that pretty well. I'd just like to apologize to the victims of the circumstances, and I'm held accountable for it. And definitely recognize my wrongs. I've been on probation for Roscommon County for almost a year with no violations or anything like that currently. So
Where are you at in terms of paying restitution in Roscommon?
I got like 1,000 left, or a little over 1,000 left.
Did you have any explanation for what was going on here? I mean, I don't see, the report doesn't indicate there's any substance abuse or anything like that.
No drugs ever in my life, alcohol socially. I had 2 really close family members pass away at the time, going through relationship hardships and stuff like that. My mom's having a bunch of health issues and all that, and everything. The 3 incidents on my report were within 3 months of each other. One of them, Roscommon County, was actually a family member that him and I had an altercation on that job that I was going to do for him, and had a disagreement, and I had misleading information on what the penalties for that would be.
All right. Well, you know, this is concerning to me, the fact that this wasn't just a one-time thing in terms of your business and taking money for work that you didn't complete, materials that you didn't purchase. The fact that you did this a couple times concerns me that this is a pattern of behavior. And I think, you know, a lot of times there's a perception that, oh, these people aren't going to miss it, they're wealthy, this is a second home, that kind of thing. But when you take money from people, you don't know how this is going to affect their financial situation. And this was a significant amount, about $4,000. And likely going to take a bit for these people to get repaid. And I think if you switch places and somebody took $4,000 from you, and think about how that would affect your life, not having that money for years sometimes to get it back, it has a real effect. And then it has a larger effect just generally on the community, on contractors. I think the victim you put in their letter, you know, they want to give work to local people, but when things like this happens, it erodes trust in the industry as a whole. And so you're not just harming the victim, you're harming other people who are trying to do the same thing you're trying to do, which is make a living doing work in the trades. So there's a much bigger effect to your crime in this case, and I think the sentence has to reflect that. I also think that the primary goal here should be the repayment of this money to the victims in this case. And I understand as a practical matter, if you're sitting in jail, that doesn't do them any good in terms of getting repaid. So I think crafting a sentence that is geared towards the repayment with consequences, if that's not happening, is an appropriate way to address this. So first of all, I think a long term of probation is appropriate for the reasons stated by the prosecutor. I think there does need to be some oversight and some supervision to make sure that to the extent this is becoming a pattern with you, that it stops now. And number two, to ensure that there is something being held over your head to make sure that this restitution gets paid. I think, the recommendation of 30 days up front is appropriate. I think the fact that you've already served 22, I'm not sure that 8 extra days is going to have a lot of effect over and above the time that you've served. So I'm not going to order any further upfront jail time. I am going to order some time held in abeyance. So the court is going to hold 8 months of that time. You've got your guidelines are 0 to 9, basically served a month, a little bit short of that. So the court's going to impose 8 months in the Otsego County Jail. The court's going to hold that time in abeyance. Actually, maybe I shouldn't say it this way for purposes of the judgment. The court's going to impose 9 months with credit for 22 days served. The court's going to hold that entire time in abeyance. I am going to ask if you can communicate this. Agent Brunical is going to be the supervising agent. If you can communicate this to Agent Brunical that I'm going to set this for review hearing every 6 months to monitor restitution. So, and understanding that you got restitution in the Roscommon case, if you're trying to pay, but you need to start making payments on this one too.
Absolutely.
And we're going to have you back here every 6 months, and there needs to be progress on the restitution.
Okay.
If there's not, then I'm going to impose some or all of that jail time. Because I want you to understand that if you're not working and if you're not paying back the restitution, that's really the only reason why I'm not giving you a jail sentence right now.
I appreciate that.
So if that's not happening, then there's no reason for me to not have you in jail.
Understand.
So I'm holding that time over your head as a motivation for you to work on paying this restitution. As long as you're paying it down and you're making diligent efforts to make payments on that, then you're not going to have to serve that jail time, because what that's telling me is you are working towards paying it off. So that's how we're going to go forward, and we're going to do that every 6 months until your probation runs out or until the restitution is paid in full. Okay.
Okay. Yeah.
The court is going to, again, place you on probation for 36 months. I'm going to adopt as the conditions of that probation all the terms and conditions listed in the report, including the jail as I specified. Restitution in the amount of $4,150 that's payable to the Otsego County Clerk to be dispersed to the victims. Also, a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state costs, along with $30 per month supervision while you're on probation. All of those fines and assessments, though, will come later after you pay your restitution. Restitution will be applied first, so that the victims get their money. All right, you do have the ability to seek an appeal of this sentence, and we're going to provide you with some paperwork that explains what your appellate rights are. Have you already had, or can you have Mr. Hackney acknowledge receipt of those, Mr.
You have signed that acknowledgement, Your Honor. I'm tendering that to the court.
Thank you. Good luck to you going forward.
Thank you.
Next hearing is set for 215, Mr. Jurist's case. I saw that he was, target records with him. So as soon as Mr. Berwick is present, we'll be in recess until that time. Okay, we're on the record in People versus Martin Jurek. This is file number 216069. The record should reflect Mr. Jurek's present here in the courtroom today. If I could have counsel put your appearances on. please.
Record showing my role down to people.
Michael Horowitz with Mr. Jurek.
All right, thank you. We're on the record here today for a resentencing hearing pursuant to a remand from the Michigan Court of Appeals. On appeal, a couple different things were addressed by the Court of Appeals opinion. First, Mr. Jurek's larceny by conversion conviction was reversed and vacated, which in and of itself would require resentencing. However, as part of the opinion, the Court of Appeals also found that the scoring OB 13 as to the remaining charges was improper. Ordered that OB 13 be scored at 0 and then remanded to this court for the purposes of resentencing. Upon receipt of that opinion, the court directed the probation department to prepare an updated pre-sentence report reflecting that ruling, taking off the conviction for larceny by conversion and rescoring the guidelines with an OB score of 0, OB 13 score of 0. I have received that report. Mr. Horowitz, did you receive that report?
Yes, sir.
Did you have a chance to go through that with Mr. Jurek?
Yes, sir.
And Mr. Jurek, did you have an adequate opportunity to talk to Mr. Horowitz about that pre-sentence report?
Yes, sir.
Okay. And Mr. Rolla, did you receive that update?
Yes, sure.
Okay. Mr. Horowitz, are there any additions, deletions, or corrections other than the jail credit that would need to be made to that report?
No, Your Honor. I don't believe so.
Do you have any additional challenges to the scoring?
No additional challenges.
Mr. Rolla, do people have any corrections, additions, deletions?
Your Honor, I would note for the record, the correction is to the jail credit was set forth, I believe, at page 3 of the updated PSI.
Okay. Any other challenges to the report?
No, Your Honor.
Anything that you wish to state by way of allocution today?
Court was here for the jury trial. This is a situation where even with the sentence that was originally imposed, since the guidelines in this case come out to 19 to 76, even with the court to impose its original sentence, it would still be within the guidelines. Thank you.
Thank you, Mr. Horowitz.
And Your Honor, I think that's accurate that the court's sentence that it previously imposed would still be in the guidelines. But
I mean, as a practical matter, it didn't really change the guidelines. It changed the lower end of the OWI charge.
that's right.
Okay.
But Your Honor, I think more importantly, the OB points really reflect a way to standardize the severity of the offense in the terms of the legislature, or in the eyes of the legislature. They're trying to give us a standard way of assessing how bad a particular offense is, understanding that all of these offenses occur within a range, and they're already classified by their classification, whether it's class E or class D or class C. But even within those particular classifications, there's a range, and that's what the guidelines address. When OB 13 is scored as 0, I think that reflects a significant change in the total OB score. It's a 25-point correction, and I think that reflects a significant change to the OB points, and by extension to how we should consider the severity of the offense. Of course, Your Honor is not bound by guidelines. We know that. And Your Honor sat through the trial and has a really good idea about what this was about. Notwithstanding, I think in terms of just the attempt to standardize offenses so that there is proportionality amongst defendants across the range, when we take away 25 points from Mr. Jurek's OB score, I think that is, I think that justifies a reduction. How much so, I would leave to your honor, but the offense is almost by definition, in terms of points, less serious than we previously considered it, by virtue of the Court of Appeals saying that those 25 points don't apply. So that said, I think it warrants a adjustment downward. Again, I'd leave that up to the court. I would also say that while in custody, Mr. Jurek's completed at least one course, Thinking for Change, and at his prior facility had been employed for most of the duration. There's also some negatives listed in the pre-sentence investigation report that I can't really get around, but I think to the extent that he is incarcerated, his options are, of course, limited as to what he can do, but he is pursuing programming and rehabilitative measures. Depending on what they give him access to, he'll do what he can. So that said, Your Honor, I would also just rely to a great extent on my initial sentence memorandum that I filed back in, I guess it's 2023 at this point. But I know that Your Honor and I disagreed about the magnitude of the offense. In my opinion, in terms of these, the possible offenses within this felony classification, this particular offense, I think appeared more to be a one-off, less persistent type of offense, and doesn't have the sort of malice and bad mind that would set it apart from other offenses. That said, Mr. Jurek does have the record that he does, although most of it's pretty remote at this point. And again, Your Honor, saw the testimony and the video evidence and has your own opinions of the offense. But I'm going on. I think the bottom line is that the reduction in points warrants a reduction in the sentence. Thank you.
Mr. Chair, is there anything that you wanted to say today?
I'd like to ask for forgiveness and mercy by the courts.
Thank you. I did review the underlying file prior to the hearing today. I reviewed the transcript from the original sentencing hearing. And of course, I reviewed the updated report and the updated scoring and the effect that had on the guidelines, which, as I indicated, did not affect the guidelines on the R&O charges and did not affect the upper end of the guidelines on the WI charge. It did reduce the lower end by 3 months. So the adjustment to OB13 had no real practical effect on the guidelines range in this case. It's essentially the same as for each charge that was before. And I think that says something about the offenses in this case when you can take away 25 points and it doesn't really reduce the guidelines at all. What that tells me or reinforces to me is the seriousness of the offense in this case. And I think the fact that you can take 25 points off and it doesn't reduce the guidelines indicates to me that this is the type of offense that warrants a serious sentence, which the court did impose initially. There isn't anything about the change to OB13 or the reduction of those 25 points. Not only does it not change the guidelines, but in my view, it doesn't change the seriousness of the offense and your conduct throughout the course of this incident. And so the court would, and there's really nothing more I have to say. I read through the transcript. I think the court articulated everything that needed to be articulated in terms of justifying the sentence at the time of sentencing. There isn't anything that's happened in the interim that would change that, including the subtraction of 25 points. So for those reasons, and relying on the court's prior allocution during the original sentencing hearing, the court finds that the same sentence is warranted as to the operating while intoxicated, third offense to court, it's going to sentence you to 46 months to 40 years in the Michigan Department of Corrections. You do have credit for 639 days served. As for each of the resisting and obstructing counts, the court will sentence you to 46 months to 15 years in the Michigan Department of Corrections with credit for 639 days served as to each of those charges. And again, the court will impose all the fines and costs that were imposed at the time of sentencing. You do have the ability to seek an appeal of this sentence as well. Mr. Horowitz, can you have Mr. Jurek acknowledge receipt of his appellate rights?
There's
Sorry, let's say proceeding.
Okay, Your Honor, you want one copy back, is that correct?
Yes.
Mr. Roll, anything further we need to address for the record today? Mr. Horowitz.
No, Judge, thank you.
Mr. Jurek, you're remanded to the custody of the state at this time.
Sorry, Judge, did the court state the amount of credit that he's received? Do we need to address that?
I did. It's calculated at 639 days
Okay, thank you.
as to each charge. Mr. Faber, were you ready with Ms. Rogers' case? Can you grab?
I know off the record, but the 639 is what I also kept. Thank you.
On record and Michelle Rogers, file number 6005, reference to reflect that Ms. Rogers is present here in the courtroom today. Counsel, with your appearance.
On behalf of Mr. Rogers.
Thank you. This is the date and time set for sentencing in this matter. Ms. Rogers, did you have a chance to read through the pre-sentence report and talk to Mr. Faber?
I did.
Mr. Faber, are there any additions, deletions, or corrections to that report?
Okay.
Are there any challenges to the scoring guidelines? Mr. Rolla, do the people have any additions, deletions, or corrections?
I don't think so, Judge.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Judge, it's the third felony, it's the third controlled substance offense. The defendant is now maintaining sobriety for apparently 134 days. I hope that's correct, because obviously that only do yourself and do society a benefit. I don't know of any documentation of physical evidence. There's a recommendation of 18 months with probation, credit, downtown, and stuff. As I understand it, I know Ms. Davis would correct me if I'm wrong, but as I understand it, this is a situation for reasons which I have no idea. The defendant law on dispense. I don't know if the recommendation all jail time being on the base. I do see, however, that we did get a report from Jessica Van Wolfen that does indicate some positive information here, that apparently Ms. Rogers has been compliant with her pretrial supervision rules and requirements. She was successfully discharged as of April 4th, 28 after being enrolled in the program for 237 days with no violations. So perhaps maybe that does confirm that she has maintained sobriety.
Thank you. Mr. Baber, anything? Yeah, Mr. Rogers.
Yes, Judge, but before may we briefly approach off record?
Sure.
Thank you. Be some proof through Jessica Van Wolfen that my client has maintained her sobriety as she has indicated. In addition, my client's been promoted at work. She's now making more money than she's ever made, and she's moving into a new household at the end of next week, which is great because she's getting her kids back at the beginning of June. So she's been working not only with Jessica Van Wolfen while out on bond to maintain contact and sobriety, but she's also been working with CPS in order to get her kids back. And the fact that she has a date set for getting her kids back, to me, shows that CPS agrees that my client has kind of made a positive turn in direction in her life. And I'm asking this court to remember the fact that there was a plea agreement for no upfront jail and to follow through with that agreement for my client. I do understand, I do think it is appropriate, given this is her third felony, that there should be some jail time that is, held in abeyance over her head. So she does know how serious she needs to take her probation and how serious she needs to take her sobriety. I'm just asking this court to consider the positive steps she's had when setting the amount of jail time that should be held in abeyance to keep to the lower half of the guidelines, somewhere between 5 and 12 months is what we're requesting at this court. Thank you, Chief.
Mr. Rogers, anything you wanted to say?
I am 146 days sober today. So and I test twice a week through DHS. So I've definitely learned my lesson. And I've learned the steps to stay sober. And I do get my kids back on June 3rd, and I do move into my house next week. So I'm on the right path for once in life. Like, I've had my fair share of mess ups, you know what I mean? But I've learned the correct way to deal with them and stay sober. I've learned the tips. I've learned the tools to deal with my, I don't want to say problems, but with my emotions and things along those lines that make me use drugs. So with all of that tools that I learned, you know what I mean? Like, I am sober now and I plan to stay this way.
I did read through the report, I'm familiar with what happened in this case and your background based on the information in that report. And it does sound like you've got a lot of things moving in the right direction now. And keep things moving in that right direction. I think at this point, given the nature of the offense here, the underlying facts, I don't think there's a lot to be gained to imposing jail time up front. And I think in a lot of ways it would be very counterproductive for you, for your sobriety, and ultimately for us as a community to have you backslide now when you got everything going the right way. So I do agree with the recommendation. I think that probation with some jail time held in abeyance, so that there's hopefully a motivation for you to continue to comply and to stay on this path and not have to go to jail and lose a lot of the things that you're going to be gaining here in the next month or so. And I think there's some indication here that you are going to be successful. So I think it's appropriate to give you that opportunity. I would tell you that aside from, the prospect of having to go to jail for violating probation, just looking at your history, you've got 1 time on probation as a juvenile and 2 times already as an adult. This will be the 3rd. One of the things that I look at at sentencing as a judge is how many times has a person been on probation? Because the more times you get to be 4, 5, 6 times on probation, and you're still back here, it starts to look like probation just isn't working, and the next option is a more serious penalty, even up to prison. I don't want that to happen to you, and I know you don't want that to happen either. So now really is the time to really focus, do the things that you need to do to get yourself in a position that you can remain sober. Sounds like you've started doing those things. I hope you continue with that. But I do want to just warn you that your chances are starting to run short. And so again, now's the time to do it. And I hope you do. So the court is going to adopt the recommendation and sentence you to probation for a period of 18 months. Court's going to adopt as the conditions of that probation all the terms and conditions listed in this report. Court is going to impose 6 months in the Otsego County Jail with credit for 1 day served. Court's going to hold that time in advance to be served at the discretion of the court. Court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350. $68 state costs. Are you retained? Oh, no, I'm sorry, I did order attorney fees. I'm sorry. I don't see the supervision fee, Ms. Davis. Is there? Oh, there it is. Okay. Also a supervision fee while you're on probation of $30 per month. You do have the ability to seek an appeal of this sentence. We're going to provide you with some papers that explain to you what your rights are, as well as how to request a court appointed attorney.
Roach?
Yes. Has Ms. Rodriguez acknowledged receipt of her appellate rights?
She acknowledges, Judge.
All right, thank you. That's all for today. Good luck to going forward.
Thank you.
Next hearing is set for 2:45. We'll take a short recess.
All rise.
Okay, we're on the record in People versus Ann Lisinski, case number 246694. The record should reflect Ms. Lisinski's present here in the court today. This is set for a probation violation hearing. And Mr. Brown, how do we want to proceed? You can be seated, I'm sorry. I don't know if I said that. No. But-
We're gonna make admission, sure.
Okay. Is there any kind of agreement, either with regard to the admissions or the sentencing or any type of agreements?
I believe there's gonna be a recommendation, but there is.
Ms. Lisinski, have you had an opportunity to speak with Mr. Brown about this?
Yes.
Is that how you want to proceed today?
Yes.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Lisinski, you understand that you have the right to have a hearing as to whether or not you violated your probation?
Yes.
You understand that by pleading guilty, you're going to be giving up that right?
Oh.
Okay, so just to explain, you would have the right to have a hearing where you could present evidence, and then the probation department would have to present evidence to prove that you actually violated your probation. By pleading guilty, you're going to be giving up the right to have that kind of hearing, and there won't be any hearing. Do you understand that?
I do.
Okay. And then the maximum possible penalty on your underlying charge, which is operating while intoxicated, third offense, is 5 years. Do you understand that? With those things in mind, what is your plea to the probation violation today?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything to get you to plead guilty?
No.
Is it your own free choice? Are you pleading guilty because you did violate your probation?
I did.
Back on March 19th of this year, 2025, you were on probation here in Otsego County, is that correct?
Yes.
Okay, and were you aware that one of the conditions of your probation was that you were to not use any alcohol?
Yes, I did.
Okay. And on or about that date, did you violate your probation by using alcohol?
Unfortunately, yes.
All right, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged. The court will accept the guilty plea. Do we want to move forward with sentencing today?
Your Honor, she is on courtesy supervision in Montmorency County. What's concerning is this was her scheduled court day that she came in under the influence of alcohol. She is though in counseling. She's completed her community service work. She is paid in full to the court. I believe though that she should remain on supervision, and I was going to ask for some additional community service work to be done in lieu of jail.
Okay. Any particular term or number of hours?
I was thinking 10 days would be appropriate. Your Honor.
Mr. Brown?
Your Honor, she was very forthcoming with me, Ms. Lisinski, when she stated she drank. She does have a lot going on in her life right now. Apparently, one of her friends just has cancer, and she has been taking care of her mother, who has dementia, is incontinent. Quite honestly, she just got overwhelmed, stressed out, and turned to something she knew to try to deal with that rather than maybe some of the tools that she's gaining from her counseling. She doesn't have acute services. She does realize that regardless of her situation, because everybody does get stressed out and everybody gets anxious, especially when you're caring for an elderly parent who she is right now, I believe even today, trying to make some preparations and doing various things that she has to do to try to get her into to a nursing home because she just simply can't keep up with the pace of caring for her. But I think maybe once that is gone, she may not have as much stress, but again, there's always going to be stress and anxiety in life. So hopefully she did learn from this, which I believe she did, and understand that if you're going to turn to something, in order to handle your stress. First of all, alcohol is gonna make it worse, especially if you're on probation. And second of all, there are other support systems you can call, or there's even hotlines people you can call your therapist, anything but that. It only makes the situation worse, and I think she realizes that.
Thank you. Anything you wanted to say, Mrs. Linsky?
I think he pretty much covered it.
I would say one other thing, Your Honor. She does not drive. She is here because her aunt drove her. I really don't know where she lives, if she's close, or how she could do certain community service work.
Well, we can certainly, I'm sure, through the probation, help accomplish that. I think that's more productive than ordering jail time. And I think there needs to be some kind of consequence here. I think that's a reasonable suggestion. Outside of having to serve jail time, you know, the concern, Ms. Lisinski, with your underlying charge is that you're continuing to use alcohol, and that presents a danger to the community, and that's part of my job to try and prevent that if I can. And recognizing that people make mistakes and slip up, you also have to understand that there's a consequence for that. And so I think given that this is a first violation, I think it's a reasonable suggestion as a way to deal with it. Going to adopt that, I think continuing you on probation is also important as well. So in terms of the sentence, the court is going to sentence you to complete community service as directed by your agent. The court is going to continue you on probation and preserve any outstanding fines or costs, continue collection. And here, I hope that you continue your counseling, things that you're undertaking to try and stay sober. Ms. Davis, does she need to check in with you today before she
And then
leaves?
she can continue referring to Legion Roads and not Is there an amount of community service work that you want her to do?
Yeah, what you directed,
10 days.
10 days, but I'll leave it at the discretion of the agent. If they want to reduce that amount, I don't have an objection.
10 days, is that 8 hour, 80 hours? I'm not sure what 10 days is.
I don't know how they do it, you know.
Usually 1 hour.
I'm leaving it within the discretion of the agent to allow for less than that if this is instance. So.
Okay.
All right. Ms. Lisinski, you do have the ability to seek an appeal of this sentence. We're going to provide you with some papers that explain what your appellate rights are, as well as how you request for help with that.
She has made that acknowledgement, Your Honor. I'm tendering that to the court.